What I wanted to do was really be quite brief here and give you a broad overview of some of the recent developments in international water law, some of the key content without going into the intricacies in any great way, and then sort of speculate a bit on some of the challenges and opportunities that I see in advancing international water law. So what are these recent developments? I see there are three key developments that have happened in recent years, which I think are really quite significant in themselves. One being the entry into force of the Convention on the Law of Non-Navigational Uses of International Watercourses, the Watercourses Convention, which happened in 2014. The next was the opening of the 92 Water Convention. So these are basically two conventions that are operating at a global level, dealing with international water law issues. And the third milestone, I think, which is really quite significant, is the introduction of the SDGs, and more particularly a target now that we have. It's on IWRM's target 6.5, but it talks about IWRM at all levels, including through transboundary cooperation, essentially requiring states to cooperate over their transboundary waters to achieve this SDG target, which I think having such a strong statement on transboundary cooperation is no mean feat. So let's go into those three milestones in a bit more detail, not in any great detail, but just some key highlights. Looking at the 97 convention, it's important to recognize that this has a long history. I mean, the UN have been working on international water law issues basically since the 1950s, when the General Assembly called on the Secretary General to look more closely at legal issues around transboundary waters, recognizing some of the difficulties and challenges that countries were having during that time in sharing some of the major rivers of the world. That led to a very lengthy development of article, basically surveying a lot of treaties at a bilateral level, a basin level, a regional level, to distill out key rules and principles on how to share transboundary waters, which ultimately became the Watercourses Convention adopted by the UN General Assembly in 1997. Since its adoption, even before its adoption, you can see that it's had a lot of influence. Even beyond the parties to the convention, you can see that it's influenced the development of treaty law. Look at the 2000 revised SADC protocol, very much in line with the Watercourses Convention. Also, freshwater disputes. It was referenced in the Gabčíkova-Načmos case on the International Court of Justice, a dispute between Hungary and Slovakia. And it continues to influence basin arrangements. You can see a lot of what's in the Nile Cooperative Framework Agreement, for example, is reflective of the provisions of the 97 Watercourses Convention. And to note, UK acceded to the convention. So then we've also got this other convention operating on a global level, dealing with transboundary water issues, the 92 Water Convention. This started as a regional convention for the UNEC region, adopted in 92 and entering into force in 1996. But in 2003, the parties took the decision to open this up to all UN member states. It took a while for that amendment to enter into force, but it became operational in 2016. And you can see already Ghana and Senegal have become parties to the Water Convention. Ghana being the last to joining both the Water Convention and the Watercourses Convention last year. I've been quite involved with the Water Convention, worked for the Secretariat there for a while, and you can see a real step change in the convention is very much acting as a global instrument. Your last meeting of the parties, for example, in 2018, 20 countries announced their intention to join the convention. In the meeting itself, around 90 countries sharing transboundary waters were represented in the meeting. So you can see it's taken on a real global role in advancing transboundary water issues. And also that's come from a very solid track record since its entry into force in 1996 of supporting countries, drafting, negotiating, implementing water arrangements, different programs, projects, soft law instruments to supplement that's been going on and continues to go on. And just to note, then UK is not a party to the Water Convention, but it is a signatory to the convention. It signed the convention in 1992. I wanted just to highlight the institutional framework under the Water Convention, and this is different to the Watercourses Convention, which doesn't have a secretariat, doesn't have a meeting of the parties. And I think this is something that's been really powerful in the success of the Water Convention, having that regular meeting, setting a program of work, activities and topics dealing with numerous issues around transboundary waters, climate change, financing, water allocation, drafting of legal agreements. I think that activity, that institutional framework has really helped advance that activity in an effective way with the support of the Water Convention Secretariat and various working groups and task force. A real great network, critical mass of countries, both parties and non-parties now, working together on these different issues around transboundary waters. Is it a good thing or a bad thing that we have these two conventions basically on the same topic? And my take is it's a good thing. They're both framework instruments, so they're very much there at a global level to supplement, support what happens at a basin level, not to replace, not to supersede, but maybe where there might be gaps within at a basin level, then some of the provisions within the conventions can help supplement, support the implementation of those basin level arrangements and address some of those gaps. You could see that. I think Vietnam joining the Watercourses Convention saw it appealing that the notification and consultation procedures, which are quite detailed within the Watercourses Convention, really supplemented what was contained at the basin level within the 95 Mekong Agreement. Both very heavily negotiated texts from very diverse groups. Even the Water Convention, while it started as a regional instrument, that's a pretty broad region, the ECE region, covering from North Africa across Europe, Central Asia. Basically, the conventions are similar in their core principles, but they also differ. Sometimes they go into one goes into a bit more detail than the other. And I see them as a great package. Together, they're a fuller package of rules and principles for supporting transboundary waters. And I think countries have seen that as well. Ghana joining the two countries at the same time, countries that are party to one deciding to join the other to promote this package of norms that they offer. There's a presumption in international law that where there are two instruments on the same topic, that they should be interpreted in a consistent manner. So I don't see there being a problem that we have these two instruments operating at the same level on the same topic. Just to give you a snapshot of where we're at in terms of being parties to one or both conventions, so you can see that in the blue are countries, 37 parties to the Watercourses Convention only, and then parties to the Water Convention, 44, and parties to both we have as 17. But I think there are a lot of countries that are looking at one or both conventions, but there's also a lot of grey, so there's a lot of countries at the moment that are not parties to either convention. Okay, that's a brief overview of the developments. What I wanted to do was also go through what are we talking about here? What's the main principles of international water law? This is founded on the principle of limited territorial sovereignty. International water law, that's where it finds its basis, what is that? Basically, states have a sovereign right to exploit their own resources, but it's a balance, right? So they have to do that in a way that doesn't harm the interests of other states. That's articulated within the principle of equitable and reasonable use as primary principle, customary international law principle and international water law, that states should weigh up all relevant factors and circumstances to balance their interests, to try to maximize the benefits of utilizing an international watercourse while minimizing any impacts. That's supplemented by the due diligence obligation to take all appropriate measures to prevent significant harm. And I think increasingly we also see, whether it's a separate principle or it's embodied within this overarching principle of equitable and reasonable use, we see the importance of ecosystems coming stronger and stronger, and the need to ensure that any uses protect the long-term viability of an international watercourse. So these are sort of the key substantive norms reflective of customary international law, and they're also very broad and open, and they're interpreted within a particular basin context. And what I think is really important, because we have these broad norms, and I don't think we could be any more prescriptive in terms of who gets what water, certainly at a global level, we have procedural norms that help to implement and constantly reevaluate the substantive norms. Institutional arrangements critical for having a platform by which to determine what is equitable and reasonable. Data exchange is obviously critical to that. Notification and consultation also features very heavily, including environmental impact assessment within international law, within international legal instruments, and so mechanisms to ensure oblige states to settle their disputes in a peaceful manner. They're the kind of key principles contained within the two conventions and reflective of customary international law. I just wanted to briefly pick up on another important development. I see this recognition, this target on transboundary cooperation, which is embedded within the SDGs, which is also supported by a specific indicator on transboundary water cooperation, an indicator looking at the proportion of a transboundary basin area with an operational arrangement for water cooperation. Countries were invited by the custodian agencies. They are UNEC and UNESCO take responsibility for this indicator. Proportion of their area is covered by an operational arrangement, and there's certain criteria for determining what is operational. And there was a great response to the first reporting exercise. So by March 2018, 107 countries had submitted reports on this indicator out of 153 countries sharing transboundary waters. There was quite a challenge in some of the data, particularly on aquifers, where states didn't have data related to their transboundary aquifers. So you can see that in the map there, the countries in yellow are countries that reported, but the data wasn't available. It wasn't possible to validate that data. A general message was that there's only 17 countries that reported have all their transboundary waters covered by operational arrangements. So a lot of gaps there, ensuring that these indicator of target is satisfied. So we're now on to the second reporting exercise. An even better response, which is brilliant. 132 countries have responded to the call to report on their operational arrangements. And so a real high, over 80% of countries sharing transboundary waters. And so there's an exercise now to review those reports, clarify any areas that need clarification. But I think the general message here is that, it's great that countries have engaged in the process, and it's also great to have at that global level a country-driven process by which countries are providing information on their status of their cooperative arrangements. I'm quite involved within this reporting process, working with UNEC and UNESCO, and we've run a lot of different workshops, developed a guide to reporting and so forth. And you can see that the one thing is the outcome and say, hey, well, we've got, this is the status of our operational arrangements around the world. But I think equally important is that what's been happening to support countries to report, and the work that countries have been doing at a national level and with their neighbours, looking at their operational arrangements and the current status. At the national level, you can see is extensive, deliberate processes where countries are reflecting on where their strengths and gaps of the arrangements that they've entered into with their neighbours. At the transboundary level, they've been, particularly if there's a river basin organisation in place, they've been using that as a mechanism to do that process at a basin level. And then I think a lot of this, the data that's coming out, saying we need more operational arrangements. We knew that already, but I think it's a bit more powerful when it's a systematic process by which countries are reporting on this, and that is feeding into different regional, global political dialogues, such as the High-Level Policy Forum on the SDGs. We've gone through these key developments with the conventions and the SDGs and looked at the core content of international water law. So where are we at? To some extent, I think it's quite encouraging that we see water security, transboundary water issues gaining greater political attention. You can see that debates in the Security Council, for example, high-level panels on water and peace, and high-level panel on water is looking at the Sustainable Development Goals, looking at encouraging, recognizing the importance of transboundary water cooperation and the conventions, and seeing that within the support of the conventions. And I think that's all really encouraging. But not so great is that, I think it reflects some of the huge pressures and challenges on the world's water resources and the key role that transboundary waters play in that, representing 60% of the flow of water. And we've got, huge uncertainties and changes in water distribution and timing availability due to climate change, which you have to have cooperation. The only way to tackle that is through cooperation. But the unilateral unilateral approaches to dealing with these issues, dealing with extreme events, is not going to work. You need the legal and institutional arrangements at the basin level, and there's still a lot of work to do to make sure that all relevant basins are covered by these arrangements. And I think in terms of getting there, I would say, if we want to put one word on it, I think the biggest challenge is sovereignty, and maybe a perceived loss of sovereignty. So this perception that countries are, by entering into these types of arrangements in resolving disputes, they're somehow giving away ownership of their water, rather than seeing these systems as shared. Sometimes even the word shared can be considered controversial or politically sensitive, but we have to recognize that these are indivisible units and unilateral approaches won't work. How do you address that? The system we have, international water law, we don't have sticks, we need carrots. It's just the nature of the international legal system that we work in. It's consent-based, and so I think the way forward is we have to show the benefits of cooperation or costs of non-cooperation. I think there's a lot of good work that's already been done on showing how cooperation can lead to multiple benefits. Typologies, for example, by Claudia Sadoff and David Gray on the benefits of cooperation, benefits for water, but also beyond water as well. Regional peace, trade, for example, can come from having focus on transboundary water cooperation, having these basin arrangements in place. Also, UNEC have worked on a methodology, a guidance on identifying, assessing and communicating the benefits of cooperation over transboundary waters, which I think can be very helpful in advancing things. So I think one thing that we've maybe not done so much work on, but I see as an important way forward, is to really demonstrate how legal institutional arrangements help deliver on equitable and sustainable water management. We tend to focus on the breaches or the problems in implementing international law, international water law, the controversial basins, but we should recognize and demonstrate more, I think, that there are a huge number of basins around the world where legal institutional arrangements are working. And I think that's a really important message to get out there and show states that even where states don't trust each other, they can have these arrangements in place which can address some of the tensions. You can see that within the Indus, for example, some of the disputes between India and Pakistan, I think, have been effectively resolved through the mechanism of the Indus Treaty. And the global conventions, also regional frameworks, you see through SADC, for example, have done a great job in supporting and strengthening that narrative of the importance of cooperation. So I think that's an encouraging trend that we need to keep pushing forward. For further information, a few papers there, and GWP have just launched a MOOC on the governance for transboundary freshwater security, running with some colleagues a module on that and international water law. So if you want to go into more detail, then that would be a good option there.